Hello, good day, welcome. This is the Employment Law Show. I am John Scholes, and joining me, Lior Samfiru, employment lawyer, of course, co-founding partner, Samfiru Tumarkin LLP. They are the most positively reviewed law firm across the country. If you need to get a hold of Lior and his team anytime during this 30 minutes or afterwards, of course, no problem. 1-855-821-5900. The number. Email is help@employmentlawyer.ca. Very simple. And a website which we're going to dive into several times, I would imagine, during this next 30 minutes, pocketemploymentlawyer.ca. Lior built that website several years ago to be used as a learning tool for you. There's all kinds of topics pertaining to employment law, things you should know basically about your work life, and also put in there as well. It used to be a separate website. Now it's rolled into Pocket Employment Lawyer. Is the severance calculator. That does exactly what it's told. It calculates your severance. Really easy to use. Takes about 30 seconds to do it. It's anonymous. No problem. That is helpful information. Again, you're going to see how it works on the show in just a little bit. Again, pocketemploymentlawyer.ca. But on the show today, Lior, we're going to talk about employment rights as they pertain to independent contractors. Many requests for this topic, so we're going to fill it on this show because people are in such a gray area when it comes to being an independent contractor. Am I not? What are the pitfalls if I'm classified incorrectly? That is all coming up, but we always start off with a week that was something you've been working on, pal. What would that be this week?
Well, John, you'd be surprised, maybe not, to know that I've been answering a lot of employment law questions. I really have. A lot of emails that people watch this show and they email me afterwards with a question about their specific situation, and that's great. That's exactly what I want you to do. If you're watching right now, it's inconceivable that in 30 minutes we'll cover every single topic that may be of relevance to you. We try to cover as much as possible, but if you have a specific issue or question, by all means, reach out to me. You can phone, you can email. We'll give you that information throughout the show because you have a right to know your rights. Okay, those rights are there for you, and unfortunately, there's no easy way to find them. You can't just go on Google and find out your rights. Can't do that, shouldn't do that. So by all means, reach out to me, have a whole team across Canada just there for you, waiting to help and make sure that at a minimum, you know what your rights are, whether you've lost your job, whether you're thinking that it's coming, you think your boss is going to be letting you go. Maybe you're put on a performance improvement plan. You don't know what to do about it. Maybe it's a situation your boss or your coworker are not treating you properly. How do you deal with that? Do you even have to? Whatever the issue, there's answers, solutions, and I promise you, there's nothing you're going to throw at me that I haven't seen before, that I haven't resolved before. So by all means, let's try it out, and happy to always connect with you. And let me give you an example of a situation that I dealt with just over the past few days. So I've said many times on the show, and hopefully by now it's clear, that for those individuals that are off on a disability leave from work, you're off, you had a medical condition, you have a right to have your job back. Your employer has to make all efforts to bring you back, and they can't avoid you. They can't say, we don't want you to do that because you've been sick. That would be illegal. Well, here's what happened with this gentleman. He had been off for a number of months, again, because of a serious medical condition. He was receiving treatment, and he was very happy, very pleased finally to get better enough to return to work. And he was hoping that his employer is going to feel the same way, to welcome him back after being off for a few months. So he contacted his employer, sent an email saying, good news, I've been cleared to go back to work. I'm ready to come back now anytime. Please let me know when I can come back. Never got a response back. Okay, employer's busy, figured no worries, I'll follow up. Sent a follow-up, again, no answer. Followed up a number of times over a period of a month or so. No answer, and nothing. Wow. Complete radio silence. As the kids say these days, I think he was being ghosted. So what does he do? He does the right thing, and he calls me. And he says, well, what do I do here? I want to go back to work. No one's getting back to me. Do I even have a job? What's going on? So bottom line is this. The fact that he's being ignored, the fact that no one is getting back to him, and certainly no one's making arrangements to bring him back to work, is the equivalent of a termination. He needs to work. He's eligible to work. The employer is not providing that work. That's a termination of employment. That could absolutely be considered a termination. But that's also potentially a human rights violation. If he's not being brought back to work because of his medical condition or because he had taken a medical leave, that's illegal. The human rights violation. Can't do that. So I always say in a situation like this is a couple of weeks, 2 or 3 weeks is reasonable to wait for your employer to get back to you. Once it's been more than 2 or 3 weeks and still nothing, yeah, it's time to consider that to be a termination. Now, I give him two options. If he actually wants to go back to work, and that's his primary objective, I can get him back to work. Because guess what? His employer is not going to ignore me. If I send that employer a letter, I'm going to get a response the same day, guaranteed. But if he doesn't want that, if he says, you know what, I'm fed up with being ignored, I just want out of there with compensation, I can make that happen as well. So if you're coming back from a medical leave, definitely talk to your employer, give them a couple of weeks to figure out what to do. But if they ignore you, if they don't bring you back, if they give you a hard time, or if they offer you a job that's unacceptable, let's talk about that. You have rights, and it's not going to be hard for me to resolve it.
Let's talk about the length of time in that or a similar situation, Lior. So someone's off, say they've been working somewhere for 10 years, they're off on a lengthy disability, and maybe after 4 years, they sever ties, very similar scenario to what you're talking about. Does that 4 years also count towards their severance, or they're just a 10-year employee at that point?
Absolutely. The time that you spent off on a medical leave, or by the way, it could be another leave, it could be a parental leave, sure, that time does count towards your seniority. And of course, that's important because the more seniority you have, the more years of service you have, the more severance you're owed. So if you've been working for 10 years and you've been off for 2 or 3 or 4 years, those years do count towards your total years of service, means you get even more severance. So again, so important to get advice because you may be surprised as to how many years of service you actually have and how much severance you're actually owed.
It's interesting, though, because this particular client was, pushing and reaching out to the employer. And as you said, radio silence, they were being ghosted. Let's flip that around another way. If you're off for a lengthy amount of time on, say, a disability leave, how often should you be contacting your employer just to check in and say, hey, I'm working on it, but I'm not ready to come back?
Now, there's no legal requirement that you contact your employer while you're off, but I always say it is a very good idea to do so. So if you're going to be off on a lengthy leave of absence for medical reasons, make it a point maybe once a month to send your employer a short note to simply say, just so you know, I'm still getting treatment. I'll let you know when there's a further update. Just a quick touch in. It doesn't have to be more than a line or two. That's all. Because you don't want your employer later to say, oh, you didn't contact us. We assumed you didn't want to come back to work. We assumed that you've resigned. Stay in touch with them. You don't need to give them a doctor's note every month. You don't need to tell them what medical treatment you're getting, just so that they know you're out there, you haven't forgotten about them, and you are planning on coming back to work at some point.
I want to make you aware of a website called employmentlawyer.ca. Of course, the firm website. There's all kinds of information there to be learned. There's also contact information. And you will find a radio station somewhere in a market near you across this country where you can tune into one of our shows. Lior and I are coming up on 10 years. We've done thousands of radio shows, and everybody's interested. They call in. They want to know more. They're hungry for their employment law rights. And we encourage you every week, if you catch a radio show near you, to call into the show. We'll give you a number wherever you are. And talk to us. Ask your questions. And if it's good, if it's interesting, if it's something a lot of people should know and learn, we'll play it back here on this TV show, which we're going to do right now. Lior, phone call number 1 is coming up. Hang on.
For the last 19 years, I've been working for one specific company, but for the last 3 years, I've been on mental disability. So my workplace called me suggesting that maybe I could try work after they couldn't find anything for me, and I have been laid off. So they have given me 11 weeks.
What kind of job were you doing?
I was working in IT.
And how old are you?
47.
Well, it fits in really nicely with what we were talking about before this call. So let's break this down a bit. First of all, the fact that the employer is saying, well, there's just no work for you, that doesn't mean that that's the truth. We need to investigate this more. Is there work, but the employer is simply choosing not to bring her back, or is there something else going on here? Because this could easily be a human rights violation, okay? Your employer can't refuse to bring you back to work. Now, if legitimately there's no work, they've tried, they've looked, there's just nothing there, a lot of things have changed while she was off, yes, then and only then can the company let her go with severance. But that's not, just because your employer is saying that that's the case, doesn't mean that it is. We need to find out a bit more. But assuming that is the case, of course she's owed severance. And the fact that she was on a disability leave, as I said, does not change that. So we know she was offered 11 weeks. How much is she really owed? By the way, it's a lot more than 11 weeks. Well, we know what we're going to do. We're going to go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. We're going to use the severance calculator tool, which you can do at home. It's free and anonymous. And let's see how much severance she's owed. So we know she's been an IT technician for 19 years. She's 47 years old. Company offered her 11 weeks. That's silly. That's ridiculous because, as you can see in the bottom of your screen, she's actually owed 16 to 20 months of severance. 16 to 20 months. And that's probably going to be a difference of more than $100,000, okay? So that's why it's so important to get that advice. That's just someone that called us on the radio, but I speak to someone in very similar situations every single day, multiple times a day. So if you're ever losing a job, junior or senior, we need to talk.
You know, it's interesting when they say they have no job, so you can go away now. Here's your pennies. We're going to offer you for severance. This comes into the conversation of what you've often referred to, Lior's duty to accommodate and the threshold of that. Talk about that for a minute.
Yeah, sometimes you may need some help to do your job. Maybe you're struggling with a medical issue. You can work, but you can't necessarily do the job the way you used to.
Right.
Maybe it's a situation where you need some modified hours. Maybe you can't work full time. Maybe you need modified duties. Maybe you need some flexibility in terms of working from home. Well, if that's what you need and that's what your doctor says that you need, your employer has to find a way to make it happen. They have that duty to accommodate, even if it's difficult. Even if they don't really think that it fits in with what the workplace is doing, they still have to find a way to make it happen if at all possible. And an employer that says, no, we're not going to accommodate. If you can come back to work full-time, fine. Otherwise, you can't. Well, that's a human rights violation. That's illegal. There's significant consequences for doing that. So something that I want all employees and employers to keep in mind.
Again, reaching out anytime, 1-855-821-5900 and help at employmentlawyer.ca for those or any other matters. Lior also does you said this on other shows, you don't know when you find time to practice law because in addition to TV and radio, you do a ton of live streaming and you're educating people every week online, both on Facebook and YouTube. You want to tune into those and maybe ask some questions at ST Lawyers. At ST Lawyers is how you find those. Want to get to first question from your live stream. Says, my boss changed my duties 2 months ago, saying the change was only temporary. I agreed to it for a short period of time. Every time I asked to be returned to my old duties, she tells me that I need to wait just a bit longer. How should I handle this?
Well, this sounds like a situation where there was an agreement. Yeah, I don't want these change of duties, but I'll agree to do it for 2 months. Well, there's no agreement beyond 2 months. An employer doesn't have the right to make significant changes to terms of employment. So this person now, potentially, depending on the types of changes, has the ability to say, wait a second, now I'm considering this to be constructive dismissal. You've changed my job. It's not the job I wanted. It's not the job that I agreed to. We never agreed for it to be more than 2 months. So now that's a constructive dismissal. That means that's a termination of her employment and she can get severance. The problem here is this. The 2 months have come and gone. If she continues working in this role for more than a few weeks, she's going to be considered to have accepted it. And now it becomes her new role. She's stuck in it, and then she can't do anything about it. So generally speaking, anytime you're facing a change to your terms of employment, hours, pay, responsibilities, you have a small window, usually of a few weeks only, to do something about it. Don't sit on those rights because they may disappear very quickly.
Independent contractors, you may be one, you may think you are one, you may know someone who thinks they are or they are not. This is a very important topic coming up here. We're going to take a short break and get into it, so you're going to learn all about that. Employment rights when it comes to independent contractors. That is on the way. The number, 1-855-821-5900. Email anytime, help at employmentlawyer.ca. More employment law shows coming up. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right. right, welcome back. Thanks for hanging through the break with us here on the Employment Law Show. I'm John Scholes. Beside me, Lior Samfiru, co-founding partner and employment lawyer, Samfiru Tumarkin LLP. You want to reach out anytime. Don't hesitate to do so. 1-855-821-5900. help@employmentlawyer.ca. Okay, Lior, we can do 10 shows just on this topic alone. I want to cover three really broad points when it comes to being an independent contractor as it pertains to employment law rights. First one is this: despite what an employer might state, many independent contractors are actually employees. How about that?
So it's important to understand who decides whether someone is an employee or a contractor. So who doesn't decide? Company doesn't decide if you're an employee or a contractor. You don't decide if you're an employee or a contractor. I don't decide if you're an employee or a contractor. The only one that can decide if you're an employee or a contractor is the law. The law makes that determination for you. So if you're not a contractor, saying that you are, someone else saying that you are, does not change that, and vice versa. Okay, so we have to be very clear on that. Therefore, signing a piece of paper that says you're an independent contractor, signing a contract that says you're being hired as an independent contractor is meaningless. It doesn't make you an independent contractor. What matters is the reality on the ground, the nature of the relationship between you and the company that you work for. The vast majority of people that think that they're independent contractors are in fact misclassified. They're really employees in the eyes of the law. So you may be looking for a job. Company says, yeah, we have work for you, but we want you to be an independent contractor. And by the way, that's a good thing for you, they'll say, because, yeah, you know, you get to file taxes different way. You can write off things. So you don't have to, you don't want to be an employee. And you know what? Maybe that's true from a tax standpoint, except it's not legal. If it was that simple, everyone can be an independent contractor, and there could be significant tax liabilities if you do it wrong, and other liabilities, which we'll talk about. So I want you, everyone out there, to remember that if you have a regular job, you're likely an employee, and most people are misclassified. And forget about a piece of paper that you sign. Doesn't matter how you pay your taxes. Doesn't matter what the company that you work for says that you are, or what you actually believe that you are. Remember, the law can only decide if you're an employee or a contractor.
Employment rights, independent contractors. Point number two is this: there are ways to tell if you are an employee or independent contractor. Break that down, Lior.
All right, so I said that most people are misclassified. So how do we actually know who is an employee and who is a contractor? So a contractor is someone that's in business for himself or herself. So a contractor is someone that runs the business. They have clients or customers. They're trying to get more clients and customers, and they provide services. So if you are an independent contractor, you may work for a company, but you don't only work for them. You have other customers, other clients that you provide services for. You manage your own business. You set your own hours. You decide who you're going to work for and how your schedule is going to be. You're going to decide how much you're going to charge for your time because you're running a business. Best example is the plumber. I use this many times. It doesn't have to be a plumber. It can be many other things, but a plumber, for example. So if a plumber comes to your home and fixes your plumbing problem, that plumber is not an employee of yours, right? Because they have many customers. They're going to finish working at your house. They're going to go to someone else's house and work for them. And they're going to try to get more customers and referrals, and they decide how much to charge. And if you want to hire them, you will, etc. That is an independent contract. That is what we're looking for. On the other hand, if the plumber goes to the same house every day, works 9 to 5 for them, gets paid a salary, and that's all they do, well, then that person would be an employee. So an employee is someone that usually doesn't provide services to many companies. It's someone that works under the direction of a company, that does what they tell them, that is getting paid an amount that the company decided, and it's someone that is integrated within the company that they work for. They're not in business for themselves. So if you want to know if you're an employee or a contractor, ask yourself, am I really like the plumber? If you are, then yeah, you're probably an independent contractor. If you're not like the plumber, you're probably an employee. You have a contract to work for a company Monday to Friday, you're going to be an employee of that company. Doesn't matter what you sign.
Point number three is this, and it's a big one again, Lior. Employees miss out on vital rights if they are incorrectly classified. We're talking about minimum wage, vacation pay, severance when they lose their job. There's a whole list of stuff, right?
Well, yeah, and that's why it's important to get this right, to get it right whether you're an employee or a contractor. Number one, even before we talk about employment law, if you've been misclassified and you really are an employee, but you've been thinking that you're a contractor, well, CRA may not be very happy with you. They may say you've been filing your taxes wrong because you've said you're a contractor, but we've assessed you as actually being an employee. So there may be back taxes owing, maybe fines, maybe penalties. Not a good place to be in. You want to get this right. But also, an employee has employment law rights. A contractor doesn't, because employment law rights only apply to employees. So if you've been misclassified, you could be giving up on rights like overtime that's owed to you, vacation pay that's owed to you. You could be giving out on a holiday pay, and of course, severance if you're let go. Most of the times when people contact me about this issue is when they lose their job. And the company they work for says, yeah, we let you go, but because you're a contractor, we don't have to pay you anything. Contractors don't get severance. Not so fast. If you've been misclassified, you are actually an employee and you're owed severance as much as 2 years' pay. So it is important to get this right. And by the way, if you want to find out if you're an employee or a contractor, not only can you call me or email me and I'll tell you, you can also do that assessment yourself. Just go to pocketemploymentlawyer.ca. Yep. We have a tool there that allows you to find out if you're a contractor or an employee. You answer a few questions and you get the answer. It's free, it's anonymous, you don't have to pay, you don't have to put in your name or number. It's there for you, and it should always be the first place you go to if you have a severance issue, if you have a question about being an employee or a contractor, or frankly, any other employment law issue.
In a minute, I want to grab another phone call from our radio show, Lior, but is there kind of an in-between category that lies between contractor and employee?
But wait, there's more. In many situations, you may not be an employee and not quite a contractor. You can be something in between. We call that a dependent contractor, not an independent contractor, but a dependent contractor. Right. A dependent contractor is a contractor, but because that contractor works a lot for one company, they do more than 70 or 80% of their work for one company, they're financially dependent on that company. That means that when that contractor is let go by that company, they're going to be owed severance pretty much like an employee because it's going to be such a big financial hit. So if you're a contractor and you have a few clients, but one is your really big client, you do the vast majority of your work for that client, if that client lets you go, even though you're not their employee, you're still going to be owed severance.
Again, employmentlawyer.ca, the place to go to find a radio station near you that carries our long-running radio show. Call number 2 from the show is coming up now, Lior.
I'm a sales executive in the technology field. I just received my quota letter. In comparison from last year to this year, my quota has increased by 140%. Commission rates have decreased by 140%. They've just given me a performance improvement plan letter. Is this something that they could possibly do, put me in a performance improvement if I don't hit the metrics that they set forth?
Wow.
So there's a few things to unpack here. First of all, from the sounds of it is they've made it harder to earn money, and they've also decided to pay less if you make those targets. So they increase the targets and are paying less commissions for hitting those targets. So that is a big deal because the net effect of that is this person is going to make less money. They're essentially taking a pay cut. So right off the bat, this could be a constructive dismissal. This absolutely could be something that allows them to say, you changed the deal. Instead of my targets being over here and my commission being this amount, you've now made the target somewhere else and are paying me less. That's not the deal we've entered into. That's a constructive dismissal. So right off the bat, you have to remember that if your commission changes, your targets are unfair, could absolutely be a constructive dismissal. Now, beyond that, it's completely unreasonable to say, we're going to double your targets and we're going to put you on a performance improvement plan if you don't hit those targets. No. So what happens if you're put on a performance improvement plan? Tell the company in writing why that's not fair, why that's unreasonable. Why is it completely improper to put you on a performance improvement plan or to complain that you don't meet those targets? Be professional, be polite. I'm not suggesting you be aggressive or rude, but put that in writing so it's clear that you're not agreeing to it. You're not saying that it's fine. By doing that, you're going to make it a lot harder for the company to use that performance improvement plan against you to let you go. So very important to do that. Dismissal.
Great phone call. Want to grab one more, but I got to take a short break. Lior first, so we'll do that and get back into it. So stick around for that. In the meantime, 1-855-821-5900 is that phone number to reach out, and the email help@employmentlawyer.ca. Coming right back. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All righty, welcome back. Employment Law Show. John Scholes here alongside Lior Samfiru. Reaching out anytime after the show is done. 1-855-821-5900. Help at employmentlawyer.ca. Lior, got a few minutes to go, so I want to get to our third phone call from our long-running radio shows right now. Listen to this.
2 months ago, my wife was terminated. She finally got a reason for the termination, that her job was redundant. Now, interestingly enough, they have people coming in what they call on-call to do what she was doing.
How long did your wife work there for?
8 years.
What kind of job was she doing?
She was a business office administrator.
And how old is your wife?
She's 49 years old.
So she lost her job, and the employer saying, well, your job is redundant. But it certainly doesn't seem like it's redundant, right? If they're having people come in to do the work, clearly there's a need there. So this may well be an employer that's not being honest about the reason. So the question, of course, is, does that actually matter? And unfortunately, it doesn't. Only because, as I said before on the show, and you heard me say on other shows, your employer can let you go for no reason or bad reason as long as severance is paid. So if they're lying about the position being redundant, that may make them not very nice people or good people, but it's not illegal. They can decide to let her go just because they want to, but severance has to be paid. So the real issue is not, is it redundant, that position? The real issue is that of severance. So let's find out how much severance this person is actually owed, because chances are she's going to be owed a lot more than what this company has offered her. So we're going to go to pocketemploymentlawyer.ca again, and we're going to use our severance calculator once again. By the way, you can do the same thing if you lost your job or are worried about it. It's free and anonymous. Let's see what this gives this particular person. 49 years of age, is an office administrator, been there for 8 years, was let go. We may think the reason is a bit nonsense. Regardless of that, we can see she's owed anywhere from 12 to 14 months of severance. Over a year's pay potentially here for her is what severance looks like. So that's why we go to pocketemploymentlawyer.ca. That's why it's so important to understand your rights, even if you're just curious, by the way. Maybe you haven't lost your job, but you've always wondered, hey, if it happens, I don't know, it could happen one day, what would I be owed? Go to pocketemploymentlawyer.ca. Have a number in your head before you do that, and check it out, and I bet you'll be surprised with the result.
And that's a big number. That's just from redundancy, so they have to pay her. Imagine if it was a human rights issue, which it wasn't, but that would be even worse.
Yeah, if she was let go for a discriminatory reason because her religion or her age, or maybe they thought that she has a disability and they don't want that, then she'd be owed additional damages as well. You can't be let go for a discriminatory reason. By the way, you also can't be let go for standing up for your rights. If you're pursuing your overtime, your vacation pay, that could be illegal as well. So what do? You call me, we talk about it, and we make sure you get what you're owed.
And that is just about it. We cover a lot. 30 minutes, man. You want to reach out now that we're done? Here's how you do that. 1-855-821-5900, the phone number. Help at employmentlawyer.ca, and that website every time, pocketemploymentlawyer.ca. It's free and anonymous. Catch you next time in the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.